legal and finance issues with COVID-19, specifically for the construction industry. So I want to thank you first for hosting today. I also want to add that we have some partners today that we want to thank Maine Aggregate Association, and we also want to thank the Maine Home Builders and Remodelers Association for joining us. The last month has been certainly challenging for the construction industry. We had a great year last year, rebuilding our industry from losing 10,000 people to finally cresting 30,000 workers in the field. And this is certainly something that none of us could have expected. But I want to say a special message to all the contractors who are on the line today. We've heard from many of you. It's been an honor working with each of you as we went through this crisis and we continue to go through this crisis. It's really been an eye-opener to everybody to see us come together so quickly to work and make sure that the safety and health of all the people on the front lines in the field and in your offices can be safe and providing important critical services for the state of Maine. With that, I want to turn this over to Ben Gilman to provide introductions about today's panelists. I want to thank everybody for joining us this morning.
Thanks, Matt, and thanks for the partnership in putting together this webinar on behalf of the construction industry. Once again, I want to, like Matt, thank our partnership with the General Contractors of Maine, the Maine Aggregate Association, and the Maine Home Builders and Remodelers to put on this presentation specifically for the construction industry. I also want to thank our sponsors for this webinar series that we're putting together at the Maine State Chamber of Commerce. The Maine Department of Economic and Community Development is our series sponsor, but I also want to thank our presenters who are also sponsors for this event today. We have Rudman and Winchell. We're going to have a legal presentation from the attorneys at Rudman and Winchell, TD Bank, also from the banking perspective, and Albion Randall and Bennett, David Jean, presenting from the financial aspects of this. So I want to thank our sponsors, also our webinar series sponsors, including Central Maine Power and Bangor Savings Bank, as well for the webinar series. This is the first of about 6 webinars that we're going to be putting on. Just want to, as we, before we introduce our speakers and the information, the format for this is going to be, so everyone knows, everyone participating, we'll have everyone muted during the presentations, and there will be a Q&A, a robust Q&A at the end. We hope that you can either ask a question in the chat room, you can see, or you can say, I have a question. We can unmute you from the chat room in order to ask the Q&A at the end. But we're going to hear both presentations first and have everyone on mute through the back end of this to ensure there's no background noise and to hear the presentation. So with that, and without further ado, we have on our legal presentation, this presentation, we do have 3 attorneys from Rudman and Winchell. We thank them for being part of this. We have Allison Economy, Josh Runlet, and Josh Tardy there in Bangor, ready to talk about the legal aspects and the impacts of dealing with the COVID-19 and specifically dealing with it from the construction industry perspective. 3 well-respected attorneys here in the state of Maine, and we're thankful to have them with us today. So with that, I'll hand it off to, I see the conference room in Bangor at Rudman and Winchell. Thanks for joining us, guys, and looking forward to hearing your presentation.
Well, thank you, Ben, and good morning, everybody. On behalf of Rudman Winchell, we'd like to thank the Chamber and AGC for this invitation to participate in this webinar this morning. We hope everybody is safe and prosperous to the extent that you can be prosperous in this changed world that we live in. I think it's safe to say that all of our worlds have changed as a result of the public health crisis that we're enduring. Business as usual is a thing of the past, and we do hope at some point it will be a thing of the future. But even essential businesses such as the construction industry and Matt, your members, have to deal with changes to how you do business safely, legally, and in compliance with all the existing orders. And that change and adjustments are being made on a daily basis, sometimes on an hourly basis. And so we'd first like to just say for those people who have questions about any of the existing orders, Matt and his team at AGC have a tremendous web resource with frequently asked questions that I think are a great resource to the construction industry. So you can go to there, and Matt, I'm sure, will make sure that everybody has access to that. But just to set sort of the context, we've been aware in the country of this imminent pandemic since maybe late December or sometime in January, sort of a fluid analysis. The Trump administration declared a public health emergency in January, and then we all watched on a daily basis as this pandemic unfolded and it came closer to our daily lives. On March 15th, Governor Mills declared a state of public health emergency, and then on March 24th, she enacted an executive order which declared essential businesses essential and shut down certain businesses such as retail and those which were classified as non-essential. And then we see flowing from that March 24th order, we see a series of orders of significance is the March 31 order, which is the shelter-in-place order. And all of those, I think it's important to note that construction, in conjunction with how the federal government has defined essential businesses and how the governor and how internally the legal teams advising the construction interest has defined construction as essential. And so that's very important. We can certainly try to answer questions at the end of this webinar as it relates to what can and can't occur during this lockdown, if you will, this shelter in place, and as we deal with Governor Mills and her executive orders, and as a society we come out of this pandemic. That basically, from a legal context, not only the courts have changed immensely as well, and so the courts are open but on a very limited basis. And only emergency types of hearings where people's liberties are directly impacted are being heard by the courts. The courts are limiting their in-court appearances to those persons who are in custody and have court appearances related to that custodial treatment, to certain child protective matters, to certain protection from abuse and protection from harassment matters that relate to domestic abuse, and there are certain other exceptions where the court is hearing cases, and then they are also adapting to the safety protocols and limiting those contacts within those court appearances. There is a catch-all provision within the main court's sort of pandemic order that allows certain cases to be heard on motion and a showing of an emergency, an extraordinary purpose, and so on a court on a case-by-case basis can entertain some motions, but the legal world as we know it has been changed significantly. So today, Allison Economy and Josh Randlett from the team here at Redmond Winchell, we're going to give a 30,000-foot overview of how legal practice as it relates to the construction industry is impacted by the pandemic, and how employment law matters. For all of you who are essential main employers, need to adjust from a legal standpoint as you have to strive to prosper as a business and survive as a business and to protect our employees as a business. So without further delay, I turn it over to Allison Economy.
Hi, thanks, Josh. Allison Economy. I am an attorney in the litigation section here. I also do a fair amount of creditors' rights work, which means I represent construction businesses who are seeking to get paid through collections actions, and also representing their claims in bankruptcy court. So my presentation today will focus on four main topics, essentially related to payment. For construction employers who are looking to receive payment for work that they've already done, for work that is already in progress, how they can seek to protect themselves for payment for work in the future, and potentially to receive payments under an existing insurance policy. So with regard to work that's already been done, obviously a typical way a construction company would go forward when they haven't been paid is to file a notice of lien, and then after that file a complaint to enforce that lien. As Josh mentioned, there have been a number of judicial orders that have gone into effect that have kind of disrupted Maine courts, particularly as it pertains to civil practice. So there aren't going to be any civil hearings until at least May. There has been a 49-day extension on pending and new deadlines. And the court clerks are working, but they're working very limited hours. So what does this mean for all of you who are having issues getting paid from a customer? Well, the important thing to know is that the extensions that have gone into effect by the courts only pertain to court orders and court rules. So they don't apply to statutory deadlines. This means that if you are going to file a notice of lien, you still have to do so within the statutory 90-day window. If you are going to file a complaint to enforce a mechanic's lien, you still have to do that within the 120-day window. Those dates are not extended by virtue of this court order, so it's important that you do not delay. The Registry of Deeds, similarly, is working on limited hours. They are processing notices of lien claims and other recorded documents by electronic filing or by mail. Most of them are not accepting documents that are being delivered directly to the registries. So if you're looking to file a notice of lien claim, it's better to have that submitted electronically and make sure that you do that with plenty of time. With courts, again, as I mentioned, the court clerks are only there limited hours. I know in Waldo County, for instance, they're only there 3 days a week from 12 to 4. So if you are waiting until the very last minute to file a complaint to enforce a lien claim, it might not actually get filed. So it's important to take those steps well in advance to make sure that you have all the time you need to get everything filed. Most sheriffs are not doing civil service right now, meaning that if you file a complaint, you won't be able to have a sheriff serve it. That's all right. You have 90 days to serve it after it's been filed. The important part is actually getting it filed. We're also using private process servers who are still serving. So if you do want to put someone on notice that complaint's been filed, we can utilize a private process server to do that. And again, the important thing is don't sit on your rights. You may have stopped work on a project and there may be a promise that the project is going to commence once things get more back to normal. And again, there may be a promise that you might start getting paid again when things get back to normal. But if you don't take steps now, you do risk losing your lien rights. And also, if you've been working with a customer who files bankruptcy, if you haven't filed a lien claim, you may be treated differently in that bankruptcy case. So if you have a claim against someone, it's better to act now and enforce those rights to make sure that you are protected to the best you can be. To the second point, how can you ensure that you are going to be paid for work that's currently in progress? So communication is key right now. Talk to the owner of the property. Make sure you're all still on the same page. Make sure that everybody knows what's going on with the work that's still underway. Again, talk to your subcontractors and your material suppliers as well. So identify a lot of potential supply chain management issues. I don't think anybody expected that we were going to run out of toilet paper, but we did. We've all seen that. And so there are a lot of other things that may be more difficult to acquire, especially as this goes on, especially goods that might be coming from a different country. So identify what might be difficult to obtain. So what happens if there are delays? Okay, well, if you don't have the required materials that you need to do a project, look for potential alternate suppliers. You can look for potential alternate materials. Make sure to track any schedule impacts. Make sure to track any increased costs. Provide notice of any potential claims that you might have to your suppliers. Make sure to update your construction schedule. And the most important thing to do is document all of this. Document all of your attempts to acquire additional materials, find alternate suppliers, things like that. And document the increased costs and document the impact on your schedule, because this will all go to your duty to mitigate your damages under the contract. And we'll talk a little bit more about that in a minute. So what happens if there are really long delays or increased costs, or you can't continue on a project for a certain reason? Well, the first thing you need to do is look at your contract. A lot of contracts have what's called force majeure provisions. And those are essentially a three-step test. So you have to show that there has been an event beyond the reasonable control of the affected party. You have to show that the party's ability to perform has been impeded by the event. And you have to show that the affected party has taken all reasonable steps to mitigate. So that's really dependent on the terms of the contract. Some provisions will include things that will actually say if there's a pandemic or an epidemic or a disease, then an extension of time may be necessary. Others refer to things like acts of God, which may need interpretation. Is the COVID-19 an act of God? Some have a catch-all provision, which say essentially that anything outside the reasonable control of the contractor may warrant an extension or a delay. Section 8.3 of the AIA contracts is entitled Delays and Extensions of Time. It says that there may be permissible extensions for unusual delays in deliveries, for other causes beyond the contractor's control, and other causes that the contractor asserts and the architect determines justify delay. So if you're operating under an AIA contract, you want to take a look at section 8.3 if you run into any delays. It's important to remember, though, that you still have to satisfy the other two steps of the force majeure test in order to take advantage of the provision. So that means you have to be unable to perform. Something like that could happen if everybody in your job site gets sick. Obviously, you can't have everybody there if people are sick. It could be that you have a delay in materials that won't let you continue the project. Usually, though, if it's just something that's going to impact your profitability, if you have to pay more because you weren't able to get materials from the supplier that you were intending to get them from, that won't constitute a force majeure provision that would give you an exception from complying with their contractual terms. And again, you always have that duty to mitigate we talked about before. So you have to consider alternatives and you have to document them. That's really important. If you determine that you are going to have an issue, provide notice. Look at your contract. It might give you a certain time frame within which you have to provide notice to the owner. If you miss that time frame, you might have waived your right to insert any additional costs associated with the delay. And also look at the method of notice. If you have to provide it by certified mail or other particular mailing, make sure that you do that. And finally, look at the owner's rights and remedies. This is important too, because sometimes if you are extending the period under a contract, under a force majeure provision, the owner then could have the right to terminate the contract. So certainly you want to be aware of that before you give notice that you're not going to be able to fulfill the contract terms as stated. The owner might also have the ability to repudiate, or to say that the contractor has repudiated the contract. So you've essentially said, I'm not going to fulfill this contract, and they can then terminate it and may be entitled to damages. So certainly you want to be aware of any damages to which they may be entitled before you give them notice of any issues under the contract. So again, the contract is key, and just make sure you know what your rights and remedies are and what the rights and remedies of the other parties are. How are you going to ensure that you will get paid for future work? Well, again, this is a good time to be reviewing contracts. If you are slow in the field right now, if you don't have as many projects going on, this is an excellent time to look at the contracts that you do have. Take into consideration what you've learned from this event. Make sure your contracts have force majeure provisions in them so that you can be protected in the event this happens again. Look to see if your contracts discuss what happens in the event of a work stoppage. If you have to clear out a site and then remobilize later, see if your contract talks about who is going to bear the risk for that and any costs associated with it. And it may be a good time to modify your contract to make sure that you're best protected in the future as you move forward with future construction projects. And finally, I just want to touch briefly on business interruption insurance. So business interruption insurance allows a business to recover certain losses in the event the business suffers physical damage that prevents it from operating its business. So there's been a lot of discussion within the court system and amongst attorneys as to whether the COVID-19 event is something that could basically implicate business interruption insurance and coverage under business interruption insurance. A lot of insurers have denied coverage because they said there's been no physical damage to the businesses. And a lot of policies also include exclusions for viral contaminations. So they're saying this COVID-19 actually falls under a coverage exclusion, and therefore there is no coverage, even though a business has been interrupted by it. Certain members of Congress have asked insurers to reconsider. They've said this is such a major event that's never happened before that we need to actually look at the insurance coverage and make sure that our insureds are getting the protections that they had anticipated getting when they took out these insurance policies. So it may be that even if you're initially denied, there are certain changes down the road that will then extend coverage. A lot of policies require prompt notice. So if your business has been interrupted, get in touch with your insurance provider now to make sure that you're properly documenting all of your losses so that if there is coverage later on, you can take advantage of that. And again, review your policy and just make sure that everything that's been lost has been properly documented. Communication is key, contracts are key, and that's it from my perspective.
Hi, everybody. My name is Josh Ranlin, and I do employment law here at Rubin Winchell. And things, as I'm sure you've seen in the news, have been moving at a breakneck speed in the employment law world with recent changes to both federal law and state law. I will try to breeze through some of these, as you might have already heard about some of them. And I know we've got other speakers that have important information to share as well. So I will try to fly through some of this stuff, but if you have any questions about any of it at the end or even after this is done, let me know. I'm always happy to talk about these things. On the state side, one of the major changes was to the unemployment compensation scheme. The changes took effect mid-March. They remain in effect through the entire time that the state of emergency is in effect and for 30 days after that. And what these changes do is they make it a lot easier for employees to get unemployment benefits. And it does it in several ways. First, it waives the 1 week waiting period, so that's good. That's less time that people are out of work without money coming in, so that's helpful. It extends who's eligible to receive these benefits. Basically, if people are temporarily out of work for a reason related to COVID-19, they're probably going to qualify. It can be a partial or a full shutdown for your place of business. It can be they're out of work because they have a quarantine or isolation order and they're not able to go to work for that. Or even if they're taking a temporary unpaid leave of absence because they're at high risk and they don't feel comfortable putting themselves out into the population. Those are all reasons why they can potentially qualify, whereas they normally wouldn't. So if you have somebody that fits into those situations, you can have that discussion with them that they might qualify for unemployment. It also waives the work search requirement, which is a good thing for both you and the employee. Typically, somebody has to show that they're out actively looking for work to qualify for benefits. For this specific scenario, as long as they remain in contact with you and they remain able to go back to work once you're open again or once their situation changes, then they don't have to go out and apply for other jobs. So that's good. And most importantly for you guys as employers, you're not going to get charged for employees who take benefits under this program. Typically, you have experience rating records, you pay unemployment contributions through taxes. Your rating record is kind of like insurance premiums, where the more people that draw against it, the more you pay into it. That's not the case here with this emergency unemployment. These benefits are going to be paid out through the state's general fund, and it's not going to be charged to you guys. So that's very, very helpful. Just keep that in mind. The $600 payments from the federal government should be coming through maybe this week, maybe next week, but that's an additional benefit that people on unemployment will get. On the federal side, there's the Family First Coronavirus Response Act, which puts into place 2 new paid leave laws. One's the Emergency Paid Sick Leave Act, and the other one's the Emergency Family Medical Leave Expansion Act. You ought to be aware of both of those. They apply to any employers with fewer than 500 employees, so that's probably going to be most of you. And here's what they do. Under the Paid Sick Leave Act, full-time employees are entitled to up to 80 hours of paid leave. Part-time is prorated, but it's 80 hours of paid leave for any of 6 qualifying conditions related to COVID-19. They're under a quarantine or isolation order. Their doctors advise them to stay home. They're sick and they're seeking diagnosis. They're caring for somebody who's under a quarantine order. Or they have a kid who they need to take care of because the school or daycare is closed. Any of those reasons can qualify for the paid leave under the law. So if you have an employee that approaches you and tells you about this, you need to have this law in the back of your mind and go look up what your obligations are. In terms of the pay, it's full 100% rate of pay if it's a condition related to the employee themselves. They're sick, they're under isolation, they're home due to doctor's orders. If it's for a reason related to somebody else other than the employee, they're caring for somebody, they're caring for kids, then it's 2/3 pay. And this overlaps a little bit with the other law that I just mentioned, the Emergency Family Medical Leave Expansion Act. That provides up to 12 weeks of job protected leave for employees who are unable to work because they have to be home caring for a minor child due to a school or daycare closure. That's the only reason that qualifies under that law. That's also one of the qualifying reasons under the other law, the 80-hour law that I talked about. Under the Emergency Family Medical Leave Act, the first 2 weeks are unpaid, but they get paid under that other law for the first 2 weeks. So bear that in mind. Weeks 3 through 12, assuming they qualify for the whole time, then they need to be paid 2/3 their regular rate of pay for that. So just like I said, putting this on your radar, if you have an employee in this situation, be aware of it and be sure that you look into what your obligations are. Flying through this, you do get to claw that money back under either of these programs. Any monies that you pay out, you get a dollar-for-dollar tax credit on your payroll tax contributions. So you get to claw that back. It's going to take a little bit of time, but you do get that money back. And then just quickly, there are posters that you guys need to post in your workplaces advising employees about these laws. They're available on the DOL website. I can shoot you a link if anybody needs it, but be aware that you need to post these posters. And on the OSHA side, OSHA just came out at the end of last week with some clarification on what your obligations are if an employee contracts COVID-19. They are relaxing their record-keeping requirements in terms of whether or not this is a work-related incident. So if you have an employee who's sick, OSHA is going to say, or they've taken the position that you don't have to report it in your OSHA 300 log unless there's objective evidence that you're aware of or you have available to you to show that this actually happened at work as opposed to the employee picking it up anywhere else in the world. So if you had an employee who you know for a fact was sick and the new employee was working closely with them and contracted it, then you might have some objective evidence that maybe employee B got this at work. Or if you have a group of 10 employees who work closely together, who all get it around the same time, then you might have some objective evidence there. But if it's an isolated incident and no specific reason for you to believe that this employee picked it up at work versus at the grocery store, then OSHA's relaxed those record-keeping requirements for you. That's a 30,000-foot view. Happy to answer any questions at the end. But with that, I'll pass the mic back off.
Thanks, guys. That was very informative and really appreciate the presentation. And as I said in the beginning, we are having a Q&A at the end. So if you do have questions, I see we already have some coming in the chat room. One other point I'd like to make before we talk about the financial is we are recording this webinar to be shared with folks that couldn't make it. And so the information is available to everyone. So just make everyone aware we are supporting this. So to switch gears from the legal end and hear a little bit about the financial end and the resources that are available, we have David Jean with us with Albion, Randall, and Bennett. He's been an advisor to the construction industry for decades, I believe now, David. We thank you for being here. We also have Jay Violet, a senior vice president with TD Bank, who also serves as the board chair of the Finance Authority of Maine. And they're going to walk through a presentation here that they put together, a PowerPoint on some of the programs and the financial tools that are now available, and also we'll have a Q&A at the end. So I'll hand it up. Thanks, David, for being here with us, and I believe we have the PowerPoint up for people to see.
Great, thank you, Ben. Welcome, everybody. It's a privilege to be here this morning and talk a little bit about some of the financial relief for the construction industry. So we're going to go through these slides with some brevity. These slides will be posted to the Maine Chamber website later, which you can download and you certainly use as a reference. But there's a lot of information to cover. So why don't we, in light of time, why don't we go right ahead? Slide, please, Age. So we're going to talk a little bit about some of the important provisions of the CARES Act that was passed by this past March 27th. It's the largest stimulus bill in history at a $2.2 trillion. And there's a number of key components included in the program. Some of it's geared specifically for individuals as well as businesses. And we're really going to kind of focus on some of the provisions that will impact the construction industry the most. We'll also touch upon the EIDL and the FAME loan programs that are available. And we're also going to throw out some suggestions in terms of how to manage cash flow during these difficult times. Jay?
Okay, Dave, I thought you were going to handle this one.
I'm more than oh, sorry. On the ADL loan, thank you. The ADL loan, this particular loan originates directly with the SBA, not the PPP program that we're going to talk about soon. So this qualifies for any business that has 500 or fewer employees, and the maximum loan is up to $2 million. The term is 30-year amortization period at a rate of 3.7%, and they do offer a deferred payments for the first 12 months. Oops, one prior. So you can actually apply for both the EID and the PPP program. The only provision is that you can't use the loan proceeds to cover the same cost. And again, this particular program, as I said, has to go directly through the SBA.gov website. You don't go through your bank through this particular program. The EID loan are not forgivable, unlike the PPP program, which we talked about in a minute. There is a $1,000 tax-free grant by applying for the loan. Whether or not you get approved or not approved, you can still keep the $10,000 tax-free grant. And in the website, the SBA says that the check upon approval will be delivered within 30 days, excuse me, within 3 days. We have not seen that. In fact, we've seen quite a bit of delays in the processing of those applications. It is interesting because last week, the Massachusetts district of the SBA issued some guidance that they would limit the $10,000 grant for $1,000 per employee up to the $10,000 limit. However, there's nothing on the SBA website that has indicated such. So I'm not sure if that is just a restriction that is placed on the Massachusetts district of the SBA, or whether or not the national SBA is going to be putting that as a condition. So it's certainly something to watch. And that loan through the EID program is available for a rollover. So if you're applying for the PP program and you have an amount outstanding under the EIDL program, then you can roll over that, which will have much more favorable rates than the EID program. This one's yours, Jay.
Yes, thanks, Dave.
Thank you.
Good morning, everyone. So there's been a lot of press out there on the PPP loans. It's a great program, although the rollout has been quite fast, all for the banks and as well for the SBA. So there are some eligibility requirements, 500 or fewer employees. However, there is some fine print there, so the larger companies may also be eligible. So check in with either your banker or your CPA firm for some of that more detailed information. Dave, maybe you can talk about the payroll costs.
Sure. So an important component of this particular program is really defining the payroll costs that are eligible for the borrowing limit, as well as those payroll costs that are eligible for forgiveness. So payroll costs include salaries, wages, similar compensation, sick, family leave pay, also includes group healthcare benefits. Those are really premiums that are paid by the employer. Payment of any retirement plan that is also paid by the employer. And there was some guidance that was issued last week that payroll costs would also include payroll that is paid to a PEO, which is essentially a employee leasing company or a similar type company, such as a management company. If you have a management company that is a common paymaster for multiple entities, you can also allocate the wages paid for each business entity. So again, there was some good clarification that took place last week. AG, next slide, please. Other costs that are included in the payroll definition is state unemployment. And yesterday, the SBA issued some guidance specifically for independent contractors and sole proprietors. So now they've given some guidance in terms of what is included in wages as reported on Schedule C. So now we have some clarification, and hopefully the banking community will adopt that so that when you're applying for the PPP loan program, that those payroll costs are much more easily identifiable. Some of the costs that are not included in payroll is any compensation on an annualized basis for anyone who makes in excess of $100,000. Employer FICA is excluded. Employees living outside the U.S., payments made to independent contractors, that was also verified, or I should say clarified, after the original bill was passed. So we know that independent contractors are excluded because essentially they'd be double dipping, because the independent contractors are also eligible for participating in the PPP program. Temporary help, at least that's the current interpretation, and there's no double dipping. So essentially, if you're paying folks who are out under the Family First Coronavirus Response Act, those wages are not eligible for borrowing, and as well as for the debt forgiveness provision.
All right, so great. So just a few basics before I dive into the actual calculation. When can you apply? You can apply now, and you should apply now if you're interested, because it's basically a first come first served basis, and the funds are I think running. I shouldn't say running low. There may be possibility of new funding, but time is of the essence. Where can you apply? You can apply through an existing SBA lender or through any FDIC insured institution, credit union, farm credit institution. So talk to your local lender. All businesses can apply, nonprofits, sole proprietorships, self-employed, independent contractors, and obviously S corps, C corps. And what do you need? You need basically payroll information. And that might include 940s, 941s, some payroll documentation to show that you have employees who were in place mid-February. And the program will last until June 30th. But that's if the funding cap is not exceeded. We talked about what you can use the loans for. The loan can be up to $10 million. And then we'll talk a little bit more, Dave will talk a little bit more about the forgiveness piece. So here, you're basically taking your average monthly payroll costs for a 12-month period. And there are some prorations that are eligible. You're eligible for if your business started, midstream in 2019, or you can look at your most recent financials. It's a little bit more of an art than a science here. Take that by 2.5 times, and you've got your loan amount. I think we talked about the eligibility, the size standard, and basically the bank's responsible for doing a good faith certification that the information that you've provided to the bank is representative of your payroll expenses. Next slide, please. Dave, I think this is yours.
So was there a slide prior to that, Angie? Okay, thank you. So allowable use of the proceeds is what we discussed. Payroll costs is previously defined. Payments of interest on any mortgage obligation, rent, utilities, and interest on any debt obligations that were in existence prior to February the 15th. And one change that was made subsequent to the bill that 75% of the loan proceeds must be used for payroll costs. So in terms of the loan forgiveness, once the funds are dispersed, the 8-week period starts at that point in time. So essentially what you're going to be able to do is you're going to be able to get during the 8-week period certain costs that are incurred, and the forgiveness can't exceed the original balance as well as any accrued interest on the loan. So again, within the 8-week period, you'll be able to get, or what will be eligible for forgiveness is all the payroll costs, interest on mortgages that existed. One distinction is that you can use the proceeds for interest on debt other than mortgages. However, when it comes to the loan forgiveness calculation, only interest on mortgages is eligible for forgiveness. So it's a bit of a subtle difference there. Accrued interest, so once the loan is dispersed, interest accrues immediately at that point in time. And not more than 25% of the loan forgiveness can be attributable to non-payroll costs. So essentially what may end up happening is that during the 8-week period, you're not spending at least 75% of payroll costs, and perhaps some of your other costs, such as utilities, rent, may not be forgiven on a proportionate basis. So it's really important to maximize the debt forgiveness that you spend at least 75% on payroll. Again, the whole impetus behind this particular program is really retention of workers and the hiring of workers. So it is very much payroll focused. So there's a tremendous amount of planning opportunities that need to happen within that 8-week period to maximize the amount that's eligible for forgiveness. Andrew, please. Now, during the 8-week period, if your headcount is reduced or if you're having salary reductions, then there are some formulas whereby some of the debt forgiveness will be reduced. There is a provision, a rehire provision, that basically states that if you rehire certain individuals and compensation is restored to its normal levels by June the 30th, then you will not be you'll be entitled to full eligibility for the debt forgiveness, or at least a phase-in. So certain conditions are required. We're getting a lot of questions on the calculations on the rehires as well as the reductions of headcount salary reduction. Unfortunately, the bill and some of the guidance published since then has really been kind of poorly written. So we're really hoping for clarifications in these regulations, hopefully sooner than later, so we can better guide business owners in terms of how to manage that debt forgiveness. And if anyone's available or interested, we do have a forgiveness worksheet that's available at our website that is quite detailed. That will help you walk through the debt forgiveness calculation. Again, it's based on what we know now, and I suspect that's going to change periodically until we hit June 30th, when essentially the program is complete. And the beautiful part about it is tax-free. That's written in the bill. I don't see that changing. And on the PPP loan, whatever's forgiven, that's going to be basically continue to be guaranteed by the SBA at 100%. The amortization period is 2 years, starting from the date of the origination. The interest is not to exceed 1%, and there's no prepayment. So for a lot of contractors that aren't going to get the full amount forgiven, it's also an opportunity that for contractors to be able to use the additional monies as really essentially an inexpensive 1% working capital over that 2-year period. So particularly as the economy hopefully will scale up and normalize soon, a lot of contractors, they're going to need some liquidity to build up their work in process, build up the receivables and so forth. So that is an advantage. The deferral of payments, deferral of 6 months, no interest or or principal. However, the interest just continue to accrue.
Just one clarification on that slide, if I may. That's correct. It continues to be guaranteed by the SBA, but there are no personal guarantees on these loans. So and there's no collateral required. So just wanted to clarify that.
Thank you, Jay.
All right. So moving on to FAME. There are 3 opportunities. 2 of them are listed here. I'll touch on the third one. There is an SBA finance loan program which provides bridge financing up to $100,000, and with that, you would need to demonstrate to the FAME lending staff that you do have an approval from the SBA. So you'd work with your bank to get that. There's a direct loan program up to $50,000, and a 12-month term. Does require an all business assets filing, doesn't have to be a first lien filing, and guarantees. And I believe in talking with Bruce at the authority that this is a quite active program right now to get some funds, sort of some emergency funds while you're waiting possibly for the PPP loans to come through. The third option, which is something that you would need to work through your bank. There is a COVID-19 relief loan insurance program that the lenders have been made aware of. So check in with your banker, and those loans are up to $100,000 with FAME insurance being allocated to that. And we did allocate, as a board, the board approved allocating $10 million in reserves for this program. It's a 12-month loan term, which can be extended possibly if necessary, interest only, on a business assets filing. We do require guarantees of the business principals, and there's a 1% guarantee fee year 1, and we are waiving our commitment fees at this time. We are running that through our online answer process, which provides the banker with an almost instantaneous approval of certain characteristics that are met within our approval system. And so that's been quite popular as well.
Great. Thank you, Jay. So I just want to move on to a couple of new credits that are part of the CARES Act. The first one being the employee retention credit. So if essentially a business is closed or suspended due to COVID-19, or they had a dramatic decrease in gross receipts, then it can essentially, they can receive a credit up to 50% of qualified wages up to $10,000, which essentially would equate to a $5,000 tax credit on a per year basis per employee. If the employer has less than 100 employees, then all employees are eligible, even if the employee is not providing services. However, if an employer has over 100 employees, full-time equivalent, then the only eligible wages are those paid to employees who are not working. So there's a bit of a subtle distinction there. The employee retention credit is not available if the employee takes a payroll protection loan. So for a lot of businesses that are participating in the PPP program, this credit is not available. However, for those that may not be eligible because of the funds may be depleted for the PPP program, this is definitely a credit that the business owners need to be aware of. Next slide, please. Okay. The next credit is the payroll tax deferral credit. So essentially, between now and the end of the year, the employer's share of Social Security only, which is the 6.2% of taxable wages, can be deferred. One half be paid by the end of 2021, the other half being paid at the end of 2022. And again, this deferral is not available for businesses that participate in the PPP program. A couple other changes. Essentially, these 2 changes were a reversal of the Tax Cut and Jobs Act of 2017. And this allows now for business owners to carry back losses that are generated in 2018, 2019, 2020. So this provides a little bit of liquidity cash flow if you've got a business that has incurred losses and you're able to claim some back taxes. Also, there's what's referred to as the retail glitch. Technical correction. So if you have a business that incurs leasehold qualified improvements, which essentially are internal improvements made to a non-residential piece of property that is non-structural in nature, you can now take 100% bonus depreciation on that, and that goes back to 18. So if you filed in 18 or 19 and you had some of those costs that were capitalized and amortized over 39 years, you can amend and you can change it to a 15-year recovery period, which is eligible for 100% write-off. So something to be mindful about. And again, opportunities to amend tax returns and claim refunds if these apply to your business. And I just kind of, in light of time, I'll kind of go through these real quickly. I just have some suggestions in terms of what business owners should be doing now during this very difficult time period. Is probably the most important thing is really develop a 13-week cash flow forecast that is basically rolling. So you're updating on a week-to-week basis. So you can identify the cash shortfall early on, so you can be prepared in terms of how you're going to handle those shortfalls. And we do have a tool available at our website if anyone's interested. We have a template that may be helpful. Talk to your bank about possible loan deferrals, both interest and principal. Vendor payment arrangements, making sure that perhaps you have some vendors that you can structure some favorable payment terms on to help delay some of the payments if need be. Open communication with customers is critically important, so you know when payments are expected. You can build that into your 13-week model. Accelerate billings, managing cash collections, particularly on the service side of businesses. Some businesses that bill weekly, perhaps you want to change that to a daily billing cycle. So you really want to condense the billing cycle as much as possible. Really monitor subcontractors and suppliers and really identify any distress signals so you can take a proactive approach and intervene if necessary to make sure that they're going to be available to provide the goods and services that are needed for the project. And perhaps a partial release of retainage. Maybe if the job is over 50% or substantially complete, maybe that can be negotiated to accelerate the payment of retainage. Inventory reduction, really important. Billing for stored materials, check your contract. If it does allow you to bill for stored materials, make sure that you get those invoices out as soon as possible. As was mentioned earlier, review your business interruption insurance, see if COVID is a covered item or not. Restricting discretionary expenses for those companies who have significant amount of equipment. Perhaps a sale leaseback of equipment to a finance company may provide you some liquidity in the short term. Increase the line of credit. Talk to your bank. If you don't have a line of credit, then talk to your bank about establishing a line of credit. And what concerns me here a little bit is if you've got covenants that are somewhat restrictive, our working capital and equity, perhaps this slowdown, you may be in default. So you really want to talk to your banker ahead of time before the line of credit renewal period to make sure that the line of credit is not going to be frozen. So you want to work with your banker and try to get a waiver ahead of time so you don't run into those situations. Closing up.
I would add something there, Dave, too, as well. If you haven't already contacted your banker asking for a deferral, from what I'm hearing, you know, we're certainly deferring, offering a 90-day deferral period, and other banks are as well. And there's some, basically some of that can be either paid on the 4th month, or there's or in equal installments starting on the 4th month, and some of the principal can be capitalized. So that's definitely a question that you should ask your banker to help with your cash flow.
Great, thank you, Chad.
Well, thank you guys for the presentation. We've already got a couple questions lined up in the queue, and I'm going to try to combine 2 of them. And if you do have a question, remember you can either ask it in the chat or you can just ask to be unmuted, and we can unmute you and you can ask your question. But we have a few questions surrounding the 75% threshold, which we've heard quite a bit about in terms of how can you use that for different costs? The 75% and the 25%, specifically transportation costs. And then also there's one question surrounding utility costs. And then how does the reduction of the forgivable loan with a, every bit below 75% that you are not that you haven't met that obligation? How does that work? Because don't know if David or Jay, I know this is new and it's a question we've been getting quite a bit, but that 75%, how is any background how that
Yeah,
may
I'm happy to address that. So in terms of the loan proceeds, again, 75% has to be used for payroll costs, and anything beyond that has to be used for those costs that are specifically identified, which is the rent, utilities, interest, and so forth. So what we're recommending is that when you do receive the loan proceeds, put that into a segregated account, and I would just fund those costs that are specifically identified, which again, payroll, utilities, and some of the other costs. So I wouldn't use that for other costs other than what's been defined.
So I'll add a little bit there. So you'll owe money if you don't maintain your staff and your payroll. So your loan forgiveness will be reduced if you decrease your full-time FTEs. Your loan forgiveness will be reduced if you decrease salaries and wages by more than 25% for any employee that made less than $100,000. And you have until June 30th to restore your full-time employment and salary levels for any changes that you made between February 15th and April 26th. And your request for loan forgiveness, you would submit a request to the lender servicing the loan, and with the appropriate paperwork to document the number of FTEs, pay rates, and your payments. You will need to certify that those are true and correct. And then the banks have 60 days to make a decision on the forgiveness.
And just to clarify too, for the FTE rehire, it doesn't have to be the same person, it's just a head count.
Very good, thank you. Legal question for the attorneys up Rudman and Winchell. We have a question here. Is the employer at risk asking the employee to stay in contact, meaning checking email without getting paid if they're on furlough or been laid off? Are they at risk for staying in contact with their employee?
Yeah, so if an employee is home on furlough or layoff, that would be a risk. You should tell them not to use their work email or phone to check emails, because the risk you run there is not only are they getting back to you about their availability, but they're answering emails on other projects or whatever. And that could count as compensable time that they would need to be paid for. So tell them not to use their work email, not to check their work email, lock that stuff down like that. For purposes of keeping in touch with the employer, I would direct the employee and have one point of contact person if possible at your workplace. It should be just a brief conversation, you know, maybe 5 minutes or so, once a week, bi-weekly, something like that, or they can shoot you a brief email from their personal account, something along those lines. If you limit it to that, I think that's a low risk scenario. And they'd be in a tough spot saying that counts as work performed for purposes of pay, especially where the unemployment law says that they have to be keeping in touch with you. But I would limit it infrequently, you know, once a week, once every 2 weeks, a very brief conversation or an email from a personal account. That's what my advice would be.
We have another legal question here. How does the 14-day self-quarantine for people coming into Maine interact with if you're an employee coming into the state and you're working for an essential business, or you're coming to work with a contractor? How does that work if you have an employee that works in New Hampshire or coming in out of state with this 14-day self-quarantine as part of, I believe, the governor's executive order?
So good question, Ben. What we're talking about is the executive order signed by the governor on April 3 that imposed travel restrictions. And for people traveling from out of state, there's a recommendation and a requirement, if you will, for 14-day self-quarantine. We believe that it does not apply to essential workers, that if it needs to be interpreted in light of the governor's other orders. And I think Matt, on behalf of his association, has gotten similar advice from the executive branch. Maybe Matt, not to put you on the spot, but I know that your webpage and your frequently asked questions refers to this very question.
Yes, we actually put the executive orders up, and then listed underneath it the discussions that we had with the governor's office. In this case, we had members who had folks actually live in New Hampshire and work here every day. They submitted directly to ask for interpretation, and they got exactly that answer, that construction is considered essential. Obviously, it gives them some flexibility with how they interpret that down the road, but that's our understanding as well, that if you're in the construction industry, you do not have to self-quarantine. I think the one exception we listed are those hotspots, which are in their executive order, which right now is New York City, Detroit, Chicago, and there was some discussion about down the road they may possibly add Boston, but as of right now, that's not in any orders that I've seen.
So are there any other questions? If someone wants to be unmuted, ask now. We are coming up on our hour. We scheduled this for an hour, but I know if there are pressing questions, we'd be happy to answer them, just either in the chat or Zoom allows you to raise a hand, so to speak. We can unmute you. That being said, we also are going to send up a follow-up email with important links that have been referred to, the presentation from the financial end of things, and also the contact information of our presenters if you do have questions as we move forward with this. So, but happy to take any other final questions if you may have it. I see we do have one from Christina Martins. Let me see if I can, Angie, if you can unmute, I will try to do that myself.
Christina, you should be good to go. I have unmuted you.
Oh, I see your question, Christine. We will be sending a link to the recording out to everyone as follow-up if you did sign up for this. I'm seeing a question that your mic is not working, so we will be sending out a link to this recording for people to share and have access to this information. I see Matt Pepin has a question. I will unmute you, Matt, or if you get to it first, Angie.
Go ahead, Matt. Are you there, Matt? You're unmuted.
You are unmuted, Matt. If you have a question, you can just ask. We do have another question, and we'll try to get back to Matt from Rosie. The expenses covered for PPP are figured from the data you receive funds. Is it the same for the EIDL loan program? That's for David or Jay.
That only applies to the PPP program.
Does not apply to the EIDL program. Right.
Matt must be having difficulty with his microphone, Ben.
Yeah. Yep. So if there are any other questions, if not, we really thank everyone for joining us today. We will be following up with an email with information and links with contact information for our presenters as well. And we really thank you for joining us in this partnership. Once again, we want to thank our partners, Associated General Contractors, Maine Aggregate Association, and also, and Matt's question has come through, and the Maine Builders Remodelers, not sponsors on the screen. Matt is asking specifically about summer help. Can you pay employees that normally work 3 to 4 months per year? His microphone is not working, so he apologizes. Anything specific in terms of summer help? In terms of I think probably referring to the PPP program or the EIDL program, the seasonal worker question.
Yeah, I'm not sure in what context. I mean, if you're hiring those people prior to June 30th, whether or not those people will help in the debt forgiveness calculation, they would. But again, I'm not sure in what context he's asking.
Okay.
He's welcome to reach out to me.
Okay, yeah, Matt, and so here we'll have David, you can reach out directly to David and ask that question in terms of the context of the seasonal employee with that. And I see a question from A. Clark. We will be providing citations and links to the temporary help guidance. I do know there's some guidance documents out there for seasonal employees, specifically for the hospitality industry, that I think would apply in that situation as well. So we'll provide some links in the follow-up with the recording of this as well. So
Ben?
again, we really appreciate all the participants, Rudman and Winchell, Albion, Randall, Bennett, and TD Bank. Thank you so much. This is very good information during these times. Together, we'll get through this, these challenging times that COVID-19 has presented to us as a community. And also to thank to our series sponsors for this. We're going to be doing one next week on workers' compensation is the next one. And we thank Central Maine Power, Bangor Savings, and Department of Economic and Community Development to help make these possible as well in these new formats. So with that, thank you very much, and don't hesitate to contact any of us if you have any other further questions. That's what we're here for. So thank you very much, and have a great day.
Thanks, Ben.